student.
So before I begin, I just want to recognize Mayor Andre Rainey is here. He's joined us, so I want to thank him for showing interest in criminal justice, for coming. So I was a student here in Peekskill High School in 1990. I was arrested and ultimately wrongfully convicted of the murder and rape of a Peekskill High School classmate. Just geographical-wise, if you're familiar with Fremont Avenue, right on the side, I was initially intercepted there by the police. I was 16 years old. Prosecutorial misconduct was a factor in my wrongful conviction. I'll share with you that I was convicted despite a pretrial negative DNA test result, and I ultimately spent 16 years in prison prior to being exonerated through further DNA testing, which not only reaffirmed my innocence, but also identified the actual perpetrator. That was 10 years ago. So you want to know if it can happen here? Yes, it happened to me. I lived in Crossroads, right on Brown Street, right across the street here. Prosecutorial misconduct was a major factor in my wrongful conviction. Let me get into that real quick. So firstly, a day before officially receiving the results from the DNA test from the FBI lab, the prosecutor rushed to the grand jury to indict me so as not to have to present that evidence. When the DNA didn't match me, the prosecutor got the medical examiner, former Westchester County medical examiner, Dr. Lewis Rowe. The medical examiner did his autopsy relatively quickly after the body of the victim was found. And 6 months later, after the DNA didn't match me, he suddenly, for the first time, claimed that he found medical evidence to show that the victim had been sexually active, which is what opened the door for the prosecutor to argue that it didn't matter that the DNA didn't match me, that the victim was basically sleeping around, and that was the explanation for the seminal fluid being present but yet not matching me. That was all a lie. You know, in order to wrongfully convict me, the prosecutor was willing to trash the reputation of the victim. Taking his lie a step, and by the way, the prosecutor knew, okay, that this new finding happened 6 months later. So hundreds of autopsies later, he claimed to remember this finding that he never previously documented. Taking his lie a step further, the prosecutor named another youth, another student from the high school that he falsely claimed had had sex with the victim. But yet he never set a proper evidentiary foundation. He never had a DNA test performed on that other student. He never even called him as a witness to give verbal testimony to that effect. He simply made the unsupported argument to the jury. As a result of that, I was wrongfully convicted. But the prosecutorial misconduct didn't end at the trial level. I sought further DNA testing, both through a letter to the DA and later on in federal proceedings. I suppose you might not technically call it misconduct, but in terms of seeking justice, it was contrary to the spirit of that. So I sought further DNA testing, and I was blocked twice. That was when Westchester District Attorney was Janine Pirro. The court clerk gave my lawyer the wrong information regarding the filing procedure. And as a result of that, when I was in federal court challenging my wrongful conviction, my petition arrived 4 days late, which the district attorney then jumped on that and urged the court to just rule that I was late without even looking at my issues, which included an argument that I was innocent based upon the DNA. Later, when I was exonerated and I filed civil suit, including against Westchester County, and they settled with me, we went to the then Westchester District Attorney, Janet DeFiore, and we expressed concern because my civil lawyers found 3 other cases that Dr. Rowe altered his findings in order to fit prosecution theory, all in tandem with that same prosecutor. And then we discovered that Dr. Rowe had been complained of in neighboring counties where he was moonlighting as a defense expert, where prosecutors and other law enforcement was complaining about him, because whichever way the money flowed is the way that he would testify. So he was helping people get away with crimes in neighboring counties. But that information was never turned over to the defense. So we went to then Westchester District Attorney Janet DiFiore, and we expressed concern about what about the other cases that Dr. Rowe testified on that, in murder cases. But she wasn't willing to audit his cases. She wouldn't support our effort. We were trying to get the feds to come in and audit his cases, but she wouldn't support that initiative. Could it be that the medical examiner she continued to use as an expert for a year and a half into her tenure? Maybe she didn't want to upset the convictions. But that's still an endeavor that hasn't been done to this day. No one has ever reviewed the other cases that he did. And to prove that he did in fact commit the misconduct, Westchester settled with me for $6.5 million. And he admitted that what he claimed he found on those slides in order to give that testimony against me did not actually exist. Let's talk about frequency. Well, the National Registry of Exonerations, which keeps track of all exonerations nationally, they're close to, if not at, 2,200 wrongful convictions across the country, both in DNA and non-DNA cases. In New York, we're third. We're third in the nation in wrongful convictions behind Texas and behind Illinois. A commonality in these wrongful conviction cases that threads through them, no matter what the cause of the wrongful conviction is, one of the commonalities that frequently is present is prosecutorial misconduct. And in terms of Peekskill itself, I'm not the only person who was exonerated from Peekskill, although that's not widely known. Charles Dabbs did 7 years from Peekskill on a rape that he did not commit, that DNA proved that he did not commit. Changing gears, let's talk about tactics, because it's one thing to share information, but I'm here for much more than that, as is everyone else. I'm here for action. I'm here for support. I'm here for solidarity. I need the people behind the bill. And for that, we need to share some move to action items. Well, first of all, one of our tactics in trying to get this bill passed is to make sure that the elected officials don't chicken out again at the end, as Bill Bastuk referred to. So to that effect, you could call, you could email, you could fax. The Westchester County elected officials, they receive me, they talk nice to me, but at the end of the day, they back off at the end. When we're at the moment of truth, when we're on the calendar now, we're waiting to get put on the calendar, or it's time to bring the bill up for a vote and we can never get that done, they back away, just like all the rest of them back away. But if they're convinced that you as their voters, as their constituents, want this bill, that you support this bill, and that that's going to have a lot to do with whether or not you vote for them again or not, if they're convinced that that's the equation, then maybe they'll stop being so afraid of the prosecutors and start being, afraid about whether they're going to get reelected or not, even though that's not supposed to be the theme. It's supposed to be do what's right because it's the right thing to do, regardless to what. But we already know that's not. Thank you. Let's hear it for that, okay? When's the last time a politician wants the office to do the right thing? Some exist. I don't think that that's a widespread thing. Now, another thing is this, is that we've been collecting resolutions from organizations. That's why I'm really so happy that the NAACP here in Peekskill is on fire for this issue. But we also been collecting resolutions from cities, towns, and counties. We need a resolution right here in Peekskill. We got the new slate, we got the new administration. We need a resolution in support of this. Postcards have worked before. The postcard campaign, sharing knowledge on the issue of prosecutorial misconduct. Again, the job of the prosecutor is not simply to win convictions, okay? It's to do justice. Now that means convicting guilty people through lawful means using legally obtained evidence while not violating any rights. And it means dismissing cases when somebody is innocent, whether that's whether that's pre-conviction, during the trial, post-conviction, at any point. That's what it means. And so when the prevalence of prosecutorial misconduct, which takes place now where there's no deterrence, they're not afraid to engage in the misconduct. And listen to the type of misconduct that's regularly engaged in. Withholding evidence of innocence. They're supposed to turn that over. That's called Brady. That's called Rosario. Imagine defending yourself in a case and evidence of innocence that could be used to help the defense. That's withheld. Imagine where somebody is testifying and they got a benefit for their testimony. They got a financial reward, they got charges not brought against them, or they had their own case and they got a lesser sentence. But that information was never turned over to you or your attorney. But that's another common form of misconduct. If there's any parents out there in the audience, and I hope that there's quite a bit, imagine you're being threatened by the prosecutor that you're going to give the testimony that they want, or we're coming for your kids. You're going to lose custody of your kids. That's been threatened in New York, especially in Brooklyn, but prosecutorial misconduct is a problem statewide. Imagine the prosecutor gives an improper closing argument and that interferes with your fair trial rights. So therefore the reliability of the jury verdict, is not that accurate. So these are some of the common tactics, and just imagine that, they're not afraid to do it, right? The judges rarely call them out on it, and if they do happen to get caught, and it's not that easy to get caught, because if you hide and bury something, you hide and bury it, right? It's an aberration when it floats to the surface. But even if that happens, nothing's going to happen to you anyway. So what's the punishment? Where's the deterrence? My lawyers told me when I wanted them to file a complaint against my prosecutor, and I'm going to end with this, right? When I finished the civil suit, and I didn't let ne'er a person get away who had anything to do with what happened to me and caused my 16 years, I went back to my civil rights lawyers, and I trusted them because they got me justice. And I said, I want something to happen to my prosecutor. I couldn't bring the suit against him. That was dismissed because they have immunity, but let's at least file a complaint against them. My lawyer said to me, Jeff, it's a waste of time. It's a waste of money. Nothing's going to happen. That's how serious this is. And we talk about how, this can happen to anyone. I want to just acknowledge the presence of another exoneree in the room who did 17 years. Mr. Rodney Roberts is here with us tonight. So can you just stand for just a brief second? Okay, this can happen. It does happen to anyone. And with that, I'm going to end. Thank you very much for listening to me.